Good evening. How's everybody doing? Great to be learning with you on a Monday, Yom Sheni. Let's light up the darkness. Who's in the house on a Monday? Renee in Indiana, Guy in Ohio, Melissa in Great Lake, Shandor in the Bronx, Bella in Florida, Bella in Texas, Lucy in Minnesota, Lorraine in Texas. No one checking in yet on the YouTube side? Or do I need to reload? No one over there yet. I'm sure they'll make their way in. Also, Yehud in South Carolina. Welcome, everybody. An exciting daf today, page 33, here in Tractate Shevuos, the 26th volume of the Talmud. Today, opening Mishna number 3 in chapter 4. Let's get into it. And with God's help, we will complete Mishnah number 3 and get into Mishnah number 4 as well. Mishnah 3. In a case where the plaintiff said to the witnesses, I administer an oath to you, which is to say, I adjure you, right? I'm forcing you to swear. I adjure you concerning your refusal to testify, if you do not come and testify on my behalf, that I have in the possession of so-and-so a deposit and an outstanding loan and a stolen item and a lost item. And they lied in reply, saying, on our oath, we do not know any testimony on your behalf. Then they are liable only for taking one false oath of testimony, right? So this is three or four kinds of situations where if I can bring witnesses to court who will testify that somebody else has money in his possession that belongs to me because I lent it to him, or because he stole it from me, or because he found it and it belongs to me. Right? In all those cases, if I can bring the witnesses and they establish the matter that so-and-so is holding some property that belongs to me, then because of their testimony, I'm going to get money back, right? Something of monetary value. And therefore, if the witnesses withhold that testimony by falsely swearing that they don't know anything that's relevant to the case that I'm bringing before the court, then through their falsehood, through their false oath of testimony, they're causing me monetary damage, and they're going to be liable for that, right? They're going to have to bring, they're liable for a false oath of testimony that causes me a monetary loss. I'm actually not sure if they have to pay the money that I would otherwise lose. But the bottom line is they are liable to bring an offering for swearing a false oath of testimony, because that liability to bring the sin offering is reliant on them causing me a financial loss. And therefore, we would learn out that if their refusal to testify, their false oath of testimony saying they don't have any testimony to give in my case, does not cost me a monetary loss, then even though they swore falsely, they would not become liable to bring a sin offering, because the oath of testimony seems to be tied to monetary loss, right? And it's only in those cases where they cause me monetary loss and they swear falsely that they become liable to bring the sin offering. Now, here in the first case in the Mishnah, even though they're withholding testimony that somebody owes me money of 3 different kinds, because they stole something from me that they're holding a stolen item, because I lost something and they're holding it, because I lent them money and they're not paying it back, or because I deposited money with them and now they're saying that they already gave it back or they don't have it. All these 4 cases, since the witnesses only swore once saying, we don't have any information that's relevant to you, even though there are 4 matters that could be included in that, they would only become liable to 1 sin offering for having violated 1 oath of testimony by swearing falsely. Now the Mishnah continues. But If they lied in reply, saying, on our oath, we do not know that you have in the possession of so-and-so a deposit and an outstanding loan and a stolen item and a lost item, right? All four, they name them specifically that they don't know anything about it. Then they are liable for each and every one of the components of the claim. It is as though they took a separate oath with regard to each of the details of the claim. Okay, next part of the Mishnah. In a case where the plaintiff said to the witnesses, I administer an oath to you concerning your refusal to testify, if you do not come and testify, that I have in the possession of so-and-so a deposit of wheat and barley and spelt. Right? So it's the same kind of legal issue that I deposited with so-and-so some of my property, but it's three different, let's say, bundles of property, but all in the same category. I deposited, and now the Bailey, who is guarding my property, claims he doesn't have it, and these witnesses know that he does, and they swear falsely, and they swear falsely that they don't know. Then what does the Mishnah say? And they claim, we don't know any testimony on your behalf. Then they would be liable for taking only one false oath of testimony. But if they lied in reply, on our oath, we do not know any testimony on your behalf that you have in the possession of so-and-so wheat, barley, and spelt, that they specify that they don't know about the three bundles that I claim I have on deposit with this other guy, and they're swearing falsely, then they would be liable for each and every one of the components of the claim and be obligated to bring three sin offerings. Now, in a case where the plaintiff said to the witnesses, I adjure you concerning your refusal to testify, if you do not come and testify on my behalf, that I have in the possession of so-and-so an outstanding payment for damage, or an outstanding payment for half the damage, which the owner pays for damage caused by his innocuous ox or goring another animal, or with regard to an outstanding payment of double the principal that a thief must pay the owner for a stolen item, or with regard to an outstanding payment of 4 or 5 times the principal that a thief pays when he stole a sheep or an ox, respectively, and then slaughtered or sold it. Or in a case where the plaintiff said, I administer an oath to you concerning your refusal to testify, if you do not come and testify that so-and-so raped my daughter, or he seduced my daughter, or that my son struck me, or that another person injured me, or that he set my stack of grain on fire on Yom Kippur. If in any of these cases the witnesses took an oath falsely, denying any knowledge of the matter on behalf of the plaintiff, these witnesses are liable for taking a false oath of testimony. Now, what's interesting about that is in the first two paragraphs, the first two sections of our Mishnah, what we were talking about is that they have knowledge that somebody has in his possession property that belongs to me. In this last paragraph, we're talking about fines. Fines, even though they have monetary value, are in a different category than the principal, so to speak. Right? So if somebody stole, my ox, and then he slaughtered it, and then he's caught, etc., then according to Torah law, when he makes that good, he doesn't just pay me my ox, he has to pay me 5 times my ox. And that's only because the Torah says so. That is a specific law in the Torah, that one who steals an ox and then he either slaughters it or sells it has to pay 5 times the principal. That's in the category of fines. And even though fines have monetary value under Torah law, under halacha, they're treated differently than recouping the principal. And then the last set weren't things that are actual monetary value at all. It could be a death penalty in the case of somebody raped my daughter, or my son struck me, right? If a man is warned and despite the warning he strikes actual violence on his mother or father, that is a death penalty offense. or somebody who lit my stack of grain on fire on Yom Kippur. The issue there is that somebody who lights a fire on Yom Kippur, if he was forewarned and he did it anyway, could be subject to a death penalty. Now, when there's a death penalty involved, even if there are monetary damages that could be associated with the same action, it could be, depends, it could be that the perpetrator will not be liable to make restitution for the financial loss that he caused, because he's also liable to the death penalty. And when two penalties apply, we only apply the more severe penalty, as we shall see. That's the Mishnah. Now the Gemara. A dilemma was raised before the sages in a case where one administers an oath to witnesses, right, adjures them, concerning a fine. Not restitution of the principal, but a fine, a statutory fine according to Torah law. If they so in a case where somebody adjures the witnesses concerning a fine, if they do not come and testify that somebody performed an action that would render him liable to pay the plaintiff a fixed sum according to Torah as the penalty for that action, then what is the law? Is it like any other case of an oath administered to witnesses in monetary matters or not? Is this statutory fine going to be treated the same way as somebody who is adjured to swear an oath in a case involving a loss, a monetary loss? Now, the Gemara refines this dilemma. According to the opinion of Rabbi Elazar, the son of Rabbi Shimon, do not raise the dilemma. As he says, in a case where one performed an action in the presence of witnesses for which he is liable to pay a fine, and before the witnesses testified, this person who would be liable to pay the fine admitted his liability, then even though the principle is one who admits that he is liable to pay a fine is exempt from paying the fine because he admitted that he owes it, and his admission exempts him from paying it. This is, of course, before the witnesses come and establish that he's guilty. So if he admits that he is liable, that he committed the crime and he's liable to pay the fine, then he has to make restitution for what he stole, but he's exempt from paying the fine. However, according to Rabbi Elazar, the son of Rabbi Shimon, if the witnesses do come and testify after this person admitted that he owes the fine, then those witnesses will render that person liable to pay the fine, even if he admitted it before the witnesses came. This is the minority opinion of Rabbi Elazar, the son of Rabbi Shimon. In his opinion, payment of the fine is dependent upon the testimony of the witnesses, period, whether the defendant admitted it or not. In his opinion, payment of the fine is dependent on the witness's testimony, and therefore, if they lie, they are liable for taking a false oath of testimony, right? In other words, what's going to happen here is, let's say according to the majority who disagree with Rabbi Elazar, since if the defendant admits that he stole and he's liable to, let's say, pay double the principal as a fine, then he's going to have to make restitution of what he stole, but he's not going to have to pay the fine because he admitted it. Therefore, since the fine is dependent on whether he admitted it or not, we say that the fine doesn't actually have a fixed monetary value. And if the witnesses swear falsely, where if they told the truth and came and admitted and testified that this guy did steal, then there would be a liability to pay the fine. Nevertheless, if the only thing that was at stake was the fine itself, and they swore falsely, they would be exempt because we would say that the fine doesn't have a monetary value, at least not a fixed monetary value, because the defendant could get out of it by admitting it before the witnesses come. So therefore, according to the majority, if witnesses swear falsely in a case involving only a fine, they're exempt from liability to bring the sin offering. But according to Rabbi Elazar, who would say that, but whether he admits it or not, if the witnesses testify, there is going to be liability to pay the fine. So therefore, maybe if they lie, therefore they need to be liable to bring the sin offering, right? That's the nuanced issue. So says the Gemara, when should you raise the dilemma? Raise it according to the opinion of the rabbis who disagree with Rabbi Elazar, the son of Rabbi Shimon. As they say, one who admits that he is liable to pay a fine is exempt, even if afterward witnesses came and testified to his liability. So the case in the Mishna is one where the plaintiff demanded that the witnesses testify on his behalf before the defendant admitted knowledge of the fine. So now the Gemara clarifies. And the rabbis who expressed their opinion there that one who admits that he is liable to pay a fine is exempt from paying the fine, even if afterward the witnesses come and establish as a matter of eyewitness testimony that he is liable to pay it. In accordance with whose opinion do these rabbis, the majority who disagree with Rabbi Elazar, according to whom do they hold, right? Where do they get that opinion? If we say that they hold in accordance with the opinion of Rabbi Elazar, the son of Rabbi Shimon, didn't we just say that they disagreed with him? But maybe they're talking about a different opinion of Rabbi Elazar, the son of Rabbi Shimon, which is cited here. But doesn't he say a matter that causes financial loss is considered to have monetary value with regard to the oath of testimony? Witnesses who testify concerning a fine also cause financial loss, as if the individual does not admit his liability, he will be liable to pay the fine based on their testimony. So rather, apparently, the rabbis there hold in accordance with the opinion of the rabbis here, who say a matter that causes financial loss is, so he was talking about the previous Mishna on page 32, a matter that causes financial loss is not considered to have monetary value. It is according to that opinion that the dilemma is raised. What is the law in the case of witnesses in a matter that involves a fine? Do we say, since if the one liable to pay the fine admits his liability, he is exempt from paying the fine, therefore the witnesses taking the oath and denying knowledge of the matter are not denying a monetary claim, and therefore he is not liable for taking a false oath of testimony, since it's not really a monetary claim, since the defendant could escape monetary liability by admitting that he owes the fine, in which case he's exempt from the fine. Or perhaps, since now, in any event, before the witnesses have come, before the defendant has admitted that he owes the money, therefore if the witnesses come and establish that he owes it, then therefore he can't get out of it anymore, right? Or perhaps since now, in any event, the defendant has not admitted liability, so payment of the fine is dependent on the testimony of these witnesses, and it is considered a monetary matter for which they should be liable if they swear falsely that they have no knowledge of the matter. So the Gemara suggests, come in here proof from the Mishnah to resolve the dilemma. I adjure you concerning your refusal to testify, if you do not come and testify on my behalf, that I have in the possession of so-and-so an unpaid payment for damage, and likewise an unpaid payment for half the damage, in the case of an ox that gored. Now, in those cases, the witnesses can be held liable for the oath of testimony. But isn't payment for half the damage payment of a fine? According to the Torah. So since they can be adjured and incur liability in a case involving a fine, it must be that an oath of testimony, a false oath of testimony, triggers liability in the case of a fine. But the Gemara rejects this proof. Now, the Mishnah is in accordance with the opinion of one who says that payment of half the damage in the case of an innocuous ox who gored is not a fine. It's half of the actual damages because it was an innocuous ox, and the owner didn't have cause to know that his ox would gore somebody else. So even though his ox gored someone else, he's only forced to pay half of the damage that the ox caused. Now you can say that amount is reduced by Torah law, and that brings it into the realm of fines, but the half that remains, what's it coming to do? Make restitution for damage that the ox caused. So that's not really a fine. It's actually a reduced amount of actual damages. Therefore, it is monetary restitution and not a fine. And to say that witnesses who swear falsely about such a matter are liable for a sin offering does not change, deny the fact that this is a monetary matter. The Gemara asks, this works out well, or they have to pay because this is a monetary matter. Now, the Gemara asks, this works out well according to the one who says that payment of half the damage is monetary restitution. But according to the one who says that payment of half the damage is payment of a fine, then what can be said? So the Gemara answers, in his opinion, the Mishna is referring to a case where the plaintiff demands that the witnesses testify with regard to liability to pay half the damage caused in a very specific kind of way, an ox not by goring, but it created damage by kicking up pebbles as it walked, right? For example, it walked past a china shop and it kicked up pebbles and it, broke china on the tables in front of the china shop, okay? So in that situation, it's also half the damages, but it's not a fine, it's monetary restitution, right? In his opinion, the Mishna is referring to a case where the plaintiff demands that the witnesses testify with regard to liability to pay half the damage caused by pebbles inadvertently propelled by the foot of the walking animal. As they learned this law through a tradition transmitted to Moses from Sinai, that payment of half the damage in that case is not a fine, but it is specifically categorized as monetary restitution. That's a tradition we have from Mount Sinai. Therefore, no proof may be cited from the Mishnah with regard to liability for taking a false oath of testimony concerning a fine. We don't have a law that covers that case yet. So the Gemara suggests, come in here, proof from the Mishnah to resolve the dilemma. In our Mishnah, we said, I adjure you, right? The plaintiff says to the witnesses, I adjure you concerning your refusal to testify, if you do not come and testify that I have in the possession of so-and-so an unpaid payment of double the principal, for which the witnesses are also liable for taking a false oath of testimony. Well, if we're talking about double the principal, when does one become liable to pay double the principal? When he stole, like a thief. And then he gets caught, and he has to make restitution of the principal plus the principal again, double the principal. Now, that clearly sounds like a fine. And if our Mishnah said that witnesses who swear falsely in a case involving, recovering payment of double the principal, it must be that we consider payment of a fine a monetary matter, which if witnesses swear falsely that they have no knowledge of it, it triggers liability to pay the sin offering. So it must be that a false oath of testimony does cover cases involving fines, just like it covers cases involving monetary restitution, right? Let's see. Right. So if he says in our Mishnah, I adjure you concerning your refusal to testify, you do not come and testify that I have in the possession of so and so, meaning he owes me, an unpaid payment of double the principal, for which the witnesses are also liable for taking a false oath of testimony. But isn't that payment of a fine? And the Gemara responds, the liability for taking a false oath of testimony in that case is not due to their denial of knowledge of the matter with regard to the fine. Rather, the liability is due to their denial of knowledge of the matter with regard to the principal, which is a full-fledged monetary payment. If somebody owes you double the principal, it's because they stole from you. So the fine portion of that is the extra, payment of the principal, right? Double the principal. So the first half of that is just repayment of the principal. That's monetary restitution for something he stole from you. That's an obvious case of monetary loss. The additional payment of the principal again, that's the fine. But the witnesses are refusing to testify in a case where the guy owes you the principal. Plain and simple monetary restitution. So we haven't proven that if there's only a fine involved, that the witnesses swore falsely, that they would be liable for a false oath of testimony and have to bring the sin offering. So the Gemara tries again with a different proof from our Mishnah. I adjure you concerning your refusal to testify, if you do not come and testify that I have in the possession of so-and-so payment of 4 or 5 times the principal, which is definitely a fine, and the Gemara answers there too. Liability is due to their denial of knowledge with regard to the principal. Somebody stole my ox, he owes me the value of the ox. Then he's going to owe me another, 4 times the ox on top of the original payment. That's the fine. But he definitely owes me the value of the ox, so we can't say that it's in a case of pure payment of the fine that it would trigger liability, as we've been discussing. So the Gemara cites another proof from the continuation of our Mishnah. I adjure you concerning your refusal to testify if you do not come and testify that so-and-so raped my daughter or he seduced my daughter. Now there is payment of money in addition to a possible death penalty. Let's see what's going on here. In a case of raped the daughter, isn't the payment for rape and seduction a fine of 50 sela? Now this is a situation where there wasn't, we can prove that it happened, but there wasn't a forewarning. If you rape that woman, you're going to be subject to the death penalty. Okay, so the death penalty doesn't apply. But we have witnesses who can establish that it happened. Right? So in that situation, that's the case where if he seduces, the young woman, of a certain age, he's going to be forced to marry her, and he can never divorce her, and he is liable to sustain her, take care of her for the rest of his and her life, whoever dies first. So what about that? That seems like the Torah establishing a fine, which if the witnesses don't testify, won't be paid. So what about this case? Sounds like I can adjure you, and they would be liable for a false oath of testimony. So sounds like the fine situation does work. But the Gemara rejects this. There, the liability of the witnesses is due to their denial of knowledge of the matter with regard to payment for humiliation and compensation for degradation of the value of the young woman resulting from the rape or the seduction. Since she's not a virgin, if she chooses not to marry the seducer or rapist, she wants to marry someone else, likely outcome, but she's no longer a virgin, and that will actually affect the ketubah, the value of the ketubah, the way things were done in the ancient world. So even though there's a fine component to the consequences for the rapist or the seducer, there's also actual compensation for the loss, right? Since she sort of on the market of marriage now commands a lower price, and because she herself suffered humiliation, which you can collect damages for that, but that's not a fine. That is sort of restoring her what she lost, right? The humiliation that she suffered, she can collect damages for that. That is not a fine. That's damages. Those are different categories. So the Gemara asks, according to this understanding, what is the Tana teaching us with the multiplicity of cases in the Mishnah? All the cases in the Mishnah are of monetary restitution. Isn't it just all redundant? And the Gemara answers, well, in the first clause, the Tana teaches us one novel element, and in the latter clause, the Tana teaches us one novel element. In the first clause, the Tana teaches us the novel element that liability to pay for half the damage caused by pebbles is monetary restitution and not a fine. And in the latter clause, the Tana teaches us the novel element that if one says, I adjure you to concerning your refusal to testify, if you do not come and testify that he set my stack of grain on fire on Yom Kippur. And what does this law serve to exclude? It serves to exclude the opinion of Rabbi Nechonia ben Hakana. As it is taught in a Baraisa, that Rabbi Nechonia ben Hakana would deem Yom Kippur like Shabbos with regard to payment of damages. Just as in the case of one who intentionally desecrates Shabbos, he is liable to receive the death penalty and is therefore exempt from liability for payment for damage that is caused while desecrating Shabbos. So too in the case of one who intentionally desecrates Yom Kippur, he is liable to receive the death penalty and is therefore exempt from liability for payment for damage that he caused while desecrating Yom Kippur. But the Tana of our Mishnah disagrees with that ruling. So the Gemara suggests, come in here a proof from a Baraisa to resolve the dilemma of, is there liability for the false oath of testimony in a case involving only a fine? Back to that question. In a Baraisa, not our Mishnah, but in a different Baraisa, It says, if the plaintiff would say to the witness, I adjure you concerning your refusal to testify, if you do not come and testify on my behalf, that so-and-so slandered my daughter, right? Saying that she's not a virgin when in fact she is. So that so-and-so slandered my daughter. In such a case, the witnesses are liable for taking a false oath of testimony. So if the accused admitted on his own that he slandered the young woman, he is exempt from paying the fine. The only payment in the case of a husband who falsely accuses his bride of adultery, right, that she committed adultery while they were betrothed, and that's why she's not a virgin when they come to the chuppah and complete the marriage. The only payment in that case, there's no monetary restitution. There's only the payment of a fine. The only payment is the payment of a fine, and yet that baraisa says that the witnesses are liable for taking a false oath of testimony, so it must be that a false oath of testimony does apply when the payment involved is a fine. Now we're on page 33b. And the Gemara answers, in accordance with whose opinion is this baraisa? It is in accordance with the opinion of Rabbi Elazar, the son of Rabbi Shimon, who says, even if the one who is liable to pay the fine admits his liability, if the witnesses come and testify, they can render the one who performed the action liable to pay the fine. But that's a minority view. So the Gemara asks, say that the latter clause of the Baraisa, if that man admitted on his own that he slandered the young woman, he is exempt from paying the fine. So ostensibly in this, we arrive at the opinion of the rabbis who overrule Rabbi Elazar and who hold that if one who is liable admits his liability before the witnesses testify, then he is exempt from paying the fine, which is contrary to the opinion of Rabbi Elazar, the son of Rabbi Shimon. And the Gemara explains the Baraisa in its entirety is the opinion of Rabbi Elazar, the son of Rabbi Shimon, and this is what the Tana is saying in the latter clause. You find a case of one who admitted liability on his own, that he's exempt from paying the fine, only in a case where there are no witnesses at all, and he admitted liability on his own. In a case where there are witnesses, he is liable to pay the fine on the basis of their testimony, even if he admitted his liability. And that concludes our discussion of Mishnah number 3. Now we move on to Mishnah number 4 here in chapter 4. In a case where the plaintiff said to two witnesses, I adjure you concerning your refusal to testify if you do not come and testify that I am a priest, or that I am a Levite, or that I am not the son of a priest and a divorced woman, or that I am not the son of a priest and a chalutza, or that so-and-so is a priest, or that so-and-so is a Levite, or that he is not the son of a priest and a divorced woman, or that he is not the son of a priest and a chalutza. In all these cases, the witnesses are exempt from liability for taking a false oath of testimony because these cases do not involve monetary claims. Right? If somebody says, he's a Cohen, right, the son of a Cohen, the son of a priest, but somebody comes and claims that, yeah, he's the son of a Cohen, but when his father married his mother, she was a divorcee. And a Cohen who marries a divorcee and they have a son, he is known as a halal, right? Who is a Cohen, but who's disqualified from serving in the Holy Temple in Jerusalem when the temple is standing. Now this guy says, no. The people who are claiming that my mother was divorced at the time my father married her, they are liars, or they just heard hearsay, but here's somebody who knows the truth, right? And so he adjures this witness to come and swear what actually happened, that he knows. But this guy says, I don't know anything about it. He doesn't want to get involved. Okay, well, then this Cohen, he wants to serve in the temple, and he needs this guy to come and testify on his behalf. So even though this guy swears falsely that he has no knowledge, when in fact maybe he does have knowledge, even if he did come and swear and reestablish this Cohen to his position in the Holy Temple, we don't ascribe a fixed financial value to that. We can't say what the financial value of that is. It's important to the Cohen, but it's not a monetary matter, and therefore, if the witness swears falsely that he has no knowledge, he's done something wrong. He's definitely violated the law. He's going to need to atone for that, and he's going to be held accountable when he leaves this world and meets his maker, or perhaps he'll be punished sooner than that. But it's not going to trigger, if we can establish that it's false, it's not going to trigger a sin offering, because sin offerings for swearing a false oath of testimony is always tied to monetary matters. Likewise, if the plaintiff said to the witnesses, I adjure you concerning your refusal to testify, if you do not come and testify that so-and-so raped his daughter, or that he seduced his daughter, or that my son injured me, or that another person wounded me on Shabbos, or that he set my stack of grain on fire on Shabbos. In all these cases, these witnesses are exempt, as each case is punishable with the death penalty. And therefore, there are cases that do not involve monetary payment, even though there would be monetary damages, but according to the principle that where there is both death penalty and a monetary damages claim, we only apply the death penalty and the monetary damages don't get paid. Now, what's sort of frustrating about that is that according to that principle, even if the death penalty doesn't get applied, the financial damages don't get assessed. However, it's not as simple as that, right? And according to some, this would only be if it's a court-ordered death penalty. If we're talking about death at the hands of heaven, that principle doesn't get applied, and the financial damages do get paid. But if it's a death penalty case, even in an earthly court, then according to that principle, even if we can't convict the person of the death penalty, he skates on the financial obligation. Let's keep going here. Now the Gemara on Mishnah number 4. So the Gemara infers the reason that the witnesses are exempt in the first clause, right, which is about the one who says, come and testify that I'm a qualified Kohen or a Levite, etc. So the reason that the witnesses are exempt is that the plaintiff demanded that they testify that so-and-so is a priest or that so-and-so is a Levite, which are claims that do not involve monetary payment. But were the plaintiff to say, I adjure you concerning your refusal to testify, if you do not come and testify, that 100 dinars belonging to so-and-so are in the possession of another so-and-so, they would be liable, right? So this is different than the previous Mishnah, where he says to the witness, I adjure you to come and testify on my behalf if you claim that you do not know that Reuven has in his possession 100 dinars that belong to me, right? Now, in this Mishnah, or in the Gemara on this Mishnah, what's being suggested is, if I say to him, I adjure you to come and swear that you have not, you claim you have no knowledge. So then swear in a situation in court where this would trigger liability if you're lying, that Reuven has in his possession 100 dinars that belong to Shimon, right? So why am I asking these witnesses to swear about money that Reuven owes Shimon? Who knows? Maybe Shimon owes me, and so I want to establish that Reuven owes Shimon so that eventually Shimon will pay me back. But the fact is, can I adjure these witnesses who are claiming they have no knowledge to swear that they have no knowledge in a case that doesn't actually directly involve me, but rather that Reuven owes money to Shimon? Can I do that? Does that work? Let's see. That's so-and-so, but were the plaintiff to say, I adjure you concerning your refusal to testify, if you do not come and testify that 100 dinars belonging to so-and-so are in the possession of a different so-and-so, they would be liable. Seems like, according to this past Mishnah. But, says the Gemara, isn't it taught in the latter clause of the Mishnah on page 35a that the witnesses are exempt until they hear a demand to come and testify directly from the mouth of the plaintiff? And here the individual administering the oath is not the plaintiff, right? I can't make these witnesses swear that Reuven owes Shimon. Only Shimon can make them swear that they have no knowledge, as they claim, about Reuven owing money to Shimon. Shmuel says about this, the reference here is to a case where the individual administering the oath comes with authorization to demand that the witnesses testify on his behalf. And the Gemara asks, but didn't the sages of Nehardea say we do not write an authorization document concerning movable property? This is a special court-ordered document. But we don't do such a document about movable property. So that would mean we only do it over land, right? The opposite of movable property is land, real property. So the Gemara answers this statement that one does not write authorization for movable property applies only in a case where the respondent already denied the claim against him. But in a case where the respondent did not yet deny the claim against him, we do write authorization even for movable property. Now the sages taught, from where is it derived that the verse with regard to an oath of testimony is speaking only about cases involving a monetary claim, right? Seems like we've been assuming this law. Now we're finally getting to the heart of that question. Where do we get this? Right? That oath of testimony is only about cases involving a monetary claim. So Rabbi Eliezer says multiple instances of the term or are stated here with regard to an oath of testimony. Quote, and he hears the voice of an oath, and he is a witness, or he saw, or he knew. That's the wording in Leviticus 5:1. And multiple instances of the term or are stated there with regard to an oath on a deposit. An oath on a deposit always involves something of monetary value. Right there in Leviticus 5 verses 21 and 22, it says, and he deals falsely with his neighbor in a matter of deposit or of an outstanding loan or of robbery, or he exploited his colleague, or he found a lost item. So, just as there the verse is speaking only about cases involving a monetary claim, so too here the verse is speaking only about cases involving a monetary claim. So the claim here is, or the concept here is, that the law of the oath of testimony and one who swears falsely is directly linked through the kind of grammar that's used in the two places to the law of one who swears falsely on an oath of deposit. The oath of deposit is always about monetary matters. Sounds like the oath of testimony is only about monetary matters. The Gemara challenges this. The multiple instances of the term or that are stated with regard to a murderer from Numbers 35 verses 20 and 21. Where it says, and if he shoved him with hatred, or cast him with any vessel without lying in wait, or in enmity smote him with his hand, will prove that multiple instances of the term or are unrelated to limiting the application of the law to cases involving monetary claims, as here we have a verse in the Torah relating, which includes multiple instances of the term or, and is not speaking about monetary claims. It's speaking about murder, which is obviously a capital offense, and not about monetary restitution. It's about whether there's a death penalty going to apply or not for someone who commits murder. So the Gemara answers, one infers multiple instances of the term or with which there is an oath administered, i.e. an oath of testimony, from a verse that includes multiple instances of the term or in which there is also an oath administered. There's no oath involved in the law of did someone commit murder or not, but there is an oath involved when we're talking about witnesses who are going to swear truthfully or falsely on whether they have testimony to offer. And there is an oath involved on the oath of deposit, one who has entrusted to hold some property and now claims that it's gone. I don't have it. I didn't, it's not my fault that it's gone. And the plaintiff claims that I still have it in my possession. And so he swears that he doesn't. In both cases, we have a bunch of, phrases in a verse linked by the word or, the conjunction or, and an oath being sworn. So the fact that the verse about murder also includes the conjunction or is not relevant. But the Gemara challenges this. The multiple instances of the term or that are stated with regard to the sota, the suspected adulteress in the Torah, Numbers 5 verses 14 and 30, where it says, or if the spirit of jealousy came upon him, or a man upon whom a spirit of jealousy came, will prove that multiple instances of the term or are unrelated to a monetary claim, as these are multiple instances of the term or, and there is an oath administered, right, to the suspected adulteress, and yet there is no monetary claim. But the Gemara rejects this analysis. One infers multiple instances of the term or with which there is an oath administered and with which there is no priest administering it. i.e. the case of an oath of testimony, from the multiple instances of the term or with which there is an oath administered and with which there is no priest administering it, i.e. the oath on a deposit. But we don't look to a different law which involves multiple instances of the word or, connecting the phrases, and an oath being sworn, but where there is a priest involved, like in the case of the sota, when she says amen, amen to the oath that's administered to her in the holy temple, when the temple is standing, and drinking the bitter waters, etc. That's a very different kind of matter than a case involving monetary issues before a beis din, before a rabbinic court, not in the holy temple. And therefore, you could also say, oath on deposit, oath of testimony, that can still exist today in the absence of a holy temple, but the law of the sota does not exist today in the absence of a holy temple. So Rabbi Akiva says, and so therefore we take this sota out of it, and we have preserved our proof that false oath of testimony only relates to monetary matters, because we're learning it out from the oath of testimony, which only refers to monetary matters. Rabbi Akiva says that it is written with regard to an oath of testimony, and it shall be when he will be guilty of one of these, Leviticus 5:5, and the term of these is a restrictive expression from which it is derived. There are some of these for which he is liable, and there are some of these for which he is exempt. How so? If the plaintiff demanded testimony from the witness with regard to a monetary claim, the witness is liable for taking a false oath. If the plaintiff demanded testimony from the witness with regard to another matter, he is exempt from bringing the sin offering if he testifies falsely. Does that mean that he is excused from taking the oath? We haven't said that. Rabbi Yosei HaGalili cites a different proof and says, the verse states with regard to an oath of testimony, and he is a witness, or he saw, or he knew. Leviticus 5:1. It is with regard to testimony that is founded on sight, i.e. direct observation without knowledge of the matter, or by means of indirect knowledge of the matter without sight, that the verse is speaking. Either you saw it with your own eyes, or you come to have reliable knowledge of it some other way than seeing it with your own eyes. Sight without knowledge? How so? It is a case where the creditor claims, I counted 100 dinars for you before so-and-so and so-and-so, and the debtor responds, well, let so-and-so come and testify. This is a case of sight without knowledge, as the witnesses do not know whether the money was counted as a loan, a deposit, or repayment of a loan. They're just coming to testify that they saw money counted out and handed from one person to another. Knowledge without sight. What is that? It is a case where the creditor claims, you admitted to owing me 100 dinars in front of so-and-so and so-and-so. And the debtor replied, well, let so-and-so and so, let those two people come and testify. This is a case of knowledge of the debt without sight of the loan taking place. They didn't see the loan being the money changing hands at the time the loan was made, but they did hear the borrower admit that he owes money to the lender. Rabbi Shimon cites a different proof and says, the Torah rendered one liable if he takes a false oath here with regard to testimony, and the Torah rendered one liable if he takes a false oath with regard to a deposit. Just as there the verse is speaking of liability only in cases involving a monetary claim, so too here the verse is speaking of liability only in cases involving a monetary claim. Right? This is the most direct statement of the principle that we're trying to prove. And furthermore, one can infer this law by means of a kal v'chomer inference from the law of a deposit. If in the case of a deposit with regard to which the Torah rendered the halakhic status of women like that of men, the halakhic status of relatives like that of non-relatives, and the halakhic status of unfit witnesses like those fit to testify, and he is liable for each and every oath if the plaintiff administered several oaths to him and he denied having the deposit in his possession, whether he took the oath before a court or not before a court. And despite the broad application of the law, the verse is speaking of liability only in cases of monetary claim, right? Oath of deposit, you can make a woman swear that she is or is not holding the deposit. You can make a relative swear the same, because that is not a witness taking the oath. That's the defendant taking the oath, right? Oath of testimony, that's the witness taking the oath. So that's a little bit of a difference there. And that's why the oath of deposit, we don't say it doesn't apply to women or it doesn't apply to relatives. It does apply to those people. And nevertheless, it only applies in monetary cases. Then, and now here's the second part of the Kal V'chomer. Then, in the case of an oath of testimony with regard to which the Torah did not render the halakhic status of women like that of men, and the status of relatives like that of non-relatives, and the status of unfit witnesses like those fit to testify, and he is liable to bring only one sliding scale offering if the plaintiff administered several oaths to him and he falsely denied knowledge of the matter in the presence of a court, is it not right that the verse is speaking of liability only in cases involving a monetary claim? And the Baraisa rejects this inference. Whoa. You're extending stringency and liability in a way that sounds logical, but isn't. Says the Baraisa, what is notable about the case of a deposit? It is notable meaning in what how do we characterize it, right? In a way that's going to defy the logic that you just spoke. It is notable in that, with regard to a deposit in the Torah, it is notable in that, with regard to a deposit, the Torah did not render the halakhic status of one to whom an oath was administered by others like that of one who himself took an oath, as one to whom an oath was administered, right, one who was adjured to take an oath, is exempt. And the Torah did not render the halakhic status of one who takes an intentional false oath like that of one who takes an unwitting false oath. Will you say that the same is true with regard to the oath of testimony? As in that case, the Torah rendered the halakhic status of the one who was adjured to be the same as one who took it on his own, and the Torah rendered the halakhic status of one who takes an intentional false oath of testimony triggers the same liability to bring a sin offering as one who did it unwittingly. Therefore, the verse states the term shall sin with regard to an oath of testimony and states the term shall sin with regard to an oath on a deposit in order to derive a verbal analogy. Now we have a different linkage between the oath of testimony and the oath of deposit, using the words shall sin in both places. And just as they are concerning an oath of a deposit, an oath on a deposit, the verse is speaking only with regard to a monetary claim. So too here concerning an oath of testimony and triggering liability to bring the sliding scale sin offering, the verse is speaking only with regard to a monetary claim. And that's the proof that we're going to rest on. New subject. After presenting the different proofs cited in that Baraisa, the Gemara proceeds to analyze the opinions that were cited therein, beginning with the opinion of Rabbi Eliezer, that one derives that one is liable for an oath of testimony only if it involves a monetary claim from the case of an oath on a deposit based on multiple instances of the term or that appear in both contexts, and there is an oath with these multiple instances of the term or, and there is no priest in their context, right? That's where we ended up with that proof. So Rabba Bar Ula objects to this. The multiple instances of the term or in the verse, or if anyone shall take an oath to clearly express with his lips or to do evil or to do good in Leviticus 5:4, which is written with regard to an oath on an utterance, right? So now, today we've been talking about oath on testimony. The witness swears that he has no knowledge. Oath on a deposit, where the defendant swears that he's not holding property that belongs to the plaintiff. And now we're going back to what we learned earlier in this tractate, the oath on an utterance, where somebody swears that yesterday he did not eat a loaf of bread, or tomorrow he will not eat a loaf of bread, right? That's an oath on utterance, an oath on an utterance. Now there also we have oath and no priest involved and the conjunction or connecting phrases in the verse. And are we going to say that that only pertains to monetary matters? Sounds like no. So let's see what Ula says. Rabba Bar Ula. Rabba Bar Ula objects to this. The multiple instances of the term or in the verse, or if anyone shall take an oath to clearly express with his lips to do evil or to do good in Leviticus 5:4, which is written with regard to an oath on an utterance, will prove that one is liable even without a monetary claim, as they are multiple instances of the term or, and there is an oath in their context. There's an oath there, and there is no priest in that context, and they are not speaking with regard to a monetary claim. So this would suggest that the oath on testimony may not be limited to monetary claims, as has been claimed. So the Gemara rejects this disproof. It stands to reason that he should have derived the law with regard to an oath of testimony from an oath on a deposit and not from an oath on an utterance, due to the verbal analogy of the terms shall sin and shall sin, which is not included in the oath on an utterance. But the Gemara rejects that and says, on the contrary, he should have derived the law with regard to an oath of testimony from the law with regard to an oath on an utterance, as it is a derivation of one case for which one is liable to bring a sin offering for taking a false oath, from another case for which one is liable to bring a sin offering for taking a false oath. And this is in contrast to an oath on a deposit, for which one is liable to bring a guilt offering, which is just also an offering, but a different kind of offering, if he takes a false oath. So rather, it stands to reason that he should have derived the law with regard to an oath on a testimony from the law with regard to an oath on a deposit, as there are many elements common to both oaths, represented by the mnemonic sin, intentionally claimed from him, denied his claim and his past, just a stream of words to help us remember if we're memorizing this. So there is a verbal analogy between them, as the term shall sin appears in both contexts. In both cases, one is liable for taking a false oath intentionally. Additionally, in both cases, there is a claim presented by one of the parties and a denial of that claim by the one taking the oath. And both oaths relate to events that transpired in the past. Would you say the same about the oath on an utterance? The Gemara asks, on the contrary, should have derived the law with regard to the oath of testimony from the law with regard to an oath on an utterance, as there are many elements that are common to both oaths, represented by the mnemonic sin offering that descended and 2/1/5. In both cases, one is liable to bring a sin offering for a false oath as opposed to a guilt offering for a false oath on a deposit. In each case, the offering is a sliding scale offering as opposed to the fixed offering in the case of an oath on a deposit. In both cases, there is no payment of an additional 1/5 for taking a false oath. And in the case of a false oath on a deposit, there is payment of an additional 1/5. And the Gemara answers, these elements common to an oath of testimony and an oath on a deposit are more numerous than the elements common to an oath of testimony and an oath on an utterance. Therefore, we link the oath of testimony with the oath of deposit, and we say that liability for a false oath of testimony only triggers liability to sin offering if the testimony involved was pertaining to monetary matters, because it's linked to the oath of a deposit, which always involves monetary matters. New subject. Rabbi Akiva says that it is written with regard to an oath of testimony. And I'm almost done. Questions or comments, please get them in. Rabbi Akiva says that it is written with regard to an oath of testimony, and it shall be when he will be guilty of one of these. In Leviticus 5:5, and the term of these is a restrictive expression from which it is derived, that there are of these for which he is liable and there are of these for which he is exempt. How so? If the plaintiff demanded testimony from the witness with regard to a monetary claim, the witness is liable for taking a false oath. If the plaintiff demanded testimony from the witness with regard to another matter, he is exempt, again, from bringing the sin offering for swearing falsely. The Gemara challenges, since it is not clear from the verse for which claim one is liable and for which claim one is exempt, I will reverse it and say that one is liable only when the claim was with regard to another matter and not when it involves monetary matters. How do you know that it is monetary matters which trigger the sin offering? Maybe it's monetary matters which dismiss the sin offering. And the Gemara answers, Rabbi Akiva relies on the multiple instances of the term or, as cited by Rabbi Eliezer, to derive from an oath on a deposit that one is liable only for a false oath that involves a monetary claim when it's a false oath of testimony. From the term of these, Rabbi Akiva derives that there are some cases involving monetary claims for which one is not liable for taking a false oath of testimony. And the Gemara asks, what is the practical difference between the opinions of Rabbi Eliezer and Rabbi Akiva? With regard to which cases involving monetary claims does Rabbi Akiva hold that one is not liable for taking a false oath of testimony? And the Gemara answers the practical difference between their opinions is in the case of one who adjures a witness with regard to testimony involving land. According to Rabbi Eliezer, they are liable if they take a false oath. Certainly land has monetary value. But according to Rabbi Akiva, they are exempt in that case as it is excluded by the term of these. And the Gemara asks, and according to Rabbi Yochanan, who says there, with regard to an oath on a deposit and an oath of testimony, that in the case of one who adjures witnesses with regard to testimony involving land, the witnesses are exempt, even according to Rabbi Eliezer. What difference is there between the opinions of Rabbi Eliezer and Rabbi Akiva? And the Gemara answers the practical difference between their opinions is in the case where one administers an oath to witnesses with regard to testimony involving a fine. According to Rabbi Eliezer, they are liable, and according to Rabbi Akiva, they are exempt. Very interesting that we would take cases involving land out of the realm of cases involving monetary loss, right, or damages involving monetary value. Why would that be? Well, we know that land is treated very specially in ancient Israel, where really you don't own anything, right? The land belongs to your tribe, and if you sell it, you can only sell the use of it up until the next Jubilee, and then it comes back as an ancestral holding to your family, and perhaps that's why land is treated differently, but I'm not sure, and we have not established that yet. Okay. Sharon, wait. Isn't the lie a sin? Why should they not have consequences for that? They do. The question is whether it's the particular sin offering that is triggered for swearing a false oath of testimony, which we've now established only applies in cases of monetary value. The fact that they told a lie and swore falsely, right? So what they lose, if they swore falsely, they're going to be accountable to that before the Holy One above. What they've actually lost is the ability to get an atonement for themselves via the sin offering, right? It's a very important matter of perspective here. We've been talking about how, well, if he does this, he triggers liability for the sin offering, but if it's not an underlying monetary value, he swears falsely that he has no testimony to give in the case where he could establish someone as a fit Cohen, and he refuses to do it, and he swore falsely, and it's established that he swore falsely, that he does not have liability to bring the sin offering. But he does have that lie on his permanent record, so to speak. So even on earth, right, people are going to know that he lied, and that's going to damage his reputation intensely. But even if it doesn't come out, and only God knows, he will be held accountable for that. And if he later wants to say, I'm sorry, I lied. I bring the case again. I'm sorry that I lied that first time. Let me somehow make it up. He doesn't have the avenue of the sin offering to bring for it. And that can seem like a leniency in the discussion that we've been having, but it's actually a stringency. Lucy, it seems it would be hard to show that a witness lied about not knowing anything about a loan, etc., in a matter, or was not remembering. Right? How are we actually going to establish this? I mean, great question. In so many of these cases, right, it's almost impossible to imagine that one who swears falsely, we're later going to be able to establish that he swore falsely, unless there were other witnesses to the same matter, or he later confesses, right? But that doesn't matter in terms of what is the underlying liability. Because, for example, if he, later gets religion, let's say, and wants to come clean, or he remembers, right? He forgot and then he remembers that he actually did have that knowledge, right? And so in case of false oath of testimony, you can bring that sin offering, whether you swore falsely intentionally or unwittingly. And so you have that out, unless, right, it's a case not involving monetary loss. And finally, Sharon, if a person is seeking a witness based on a loan, and the witnesses did not see the person get the loan necessary for a purchase, for example, a house, but he saw that the person suddenly had the funds for the house, can they make testimony that the person reported they were expecting this loan to get the house, and then they bought the house? Is it improper for someone to swear they know the money was lent based on this circumstantial evidence? I hope I'm clearly stating this idea. Well, they could testify to what they saw, right? So the circumstances that you brought up, exactly, it's circumstantial evidence. So if the judges wanted to hear testimony about these other things, I suppose the judges could ask for it. But they will bear in mind that there's other possible explanations, right? Somebody could come into money suddenly, even though he had been talking about getting a loan, and he will later claim, I didn't get a loan, I inherited, or I found, a treasure came my way, bag fell off a armored car, who knows? And so the judges might take other matters into hand. What they can establish by the mouth of two witnesses is, what the lender said or what the borrower said on a certain date, when they received money, when they didn't. But what we would not say is that we have conclusively established that a loan was made, or that a person confessed that he had borrowed money. Those are off the table. We could establish other matters so that maybe the judges can establish something by the preponderance of the evidence, but they would certainly take into account that it's circumstantial evidence that they're talking about. That's what I've got for us today, and with God's help, we'll be together again tomorrow at the regular Tuesday time, 6 p.m. Pacific.